More than $14 billion was spent on the 2020 elections, which was double the amount spent just 4 years earlier. That is a lot of money for politicians to raise and spend, and for individuals and companies to donate. Political spending is a highly regulated area of the law at both the federal and state levels, and the laws apply to both those raising the money and those giving it. It's not surprising, then, that there have been many enforcement matters, indictments, and embarrassing news stories about everything from simple mistakes to criminal activity. Just recently, a Congressional Oversight Committee recommended that the Justice Department should prosecute an individual for tying campaign contributions to a presidential super PAC to a regulatory decision that the individual made that affected the donor. The bad press and publicity, or even worse, that comes from campaign finance missteps can be devastating for politically active individuals, companies, and candidates. That is why it is important to know and understand the campaign finance rules that apply to political activity, even casual political giving. Compliance really is essential to being involved in the political process. There are many good and important reasons why people want to participate in the political process. Today, we will talk about how to accomplish those goals while complying with the law to minimize the risk of enforcement or bad publicity as we talk about political giving pitfalls, campaign finance laws for you and your clients. I'm Ron Jacobs, the chair of the political law practice at Venable LLP in Washington, D.C. I have experience representing candidates, super PACs, associations, advocacy organizations, large and small companies, and individuals involved in the political process. With over 20 years of experience in the field, I'll help you to understand how to be involved in the political process without running afoul of the rules. Today, we'll cover a number of different topics to give you an overview of the rules around political giving. We'll start with an introduction to explain the rationale for how campaign finance laws work, and then turn to the specific limits and prohibitions that cause problems for those involved in the political process. Most of what we'll cover will be focused on the rules that apply to federal campaigns, those running for the President, the U.S. House, and the U.S. Senate. After that, we will talk a little bit about how state laws work, so that if you are interested in races for governor, state attorney general, or the state house in different places, you will have a good start. It's important to remember that state laws vary widely, and what is permitted in one state can be a crime in another. So with that background, let's get started. Campaign finance law has two different ways of looking at the way money is spent: contributions and expenditures. Contributions are the money and other things of value that someone gives to a political committee. A check you write to a candidate, the use of a private jet to fly a candidate to an event. Expenditures are funds that are spent to support a candidate directly. For example, if you were to buy a digital ad on social media that says, "Vote for Bob Smith for Congress," or if you were to buy a sign by the side of the road, that would be an expenditure. But the key is that an expenditure has to be done by yourself. It cannot be done at the request or suggestion of a candidate. If it's done at the request of the candidate, then it's something that's considered a coordinated contribution and becomes an in-kind contribution to the candidate. The reason the difference between a contribution and expenditure is important is that the Supreme Court has decided that there are different levels of restrictions that can be placed on contributions compared to expenditures. Contributions can only be limited based on corruption or the appearance of corruption. In other words, absent corruption or its appearance, the Supreme Court will strike down any law limiting contributions. A recent Supreme Court decision is illustrative. In that case, the court looked at statements from members of Congress, academic articles, and newspaper articles that the government put forth to try to justify a limit on repaying campaign loans. At the end of the day, the court said none of that was evidence of the appearance of quid pro quo corruption and struck down the law anyway. But there's at least a standard by which the court will uphold limits on contributions. Expenditures are a different story. The Supreme Court has said that expenditures may not be limited because an expenditure that is made without coordinating with a candidate cannot corrupt a candidate in any way, shape, or form. This is now determined as a matter of law. What this means is that for now, contributions may be limited and subject to regulation, whereas expenditures, as long as they're done independently of the candidate, are not subject to any contribution limits.